relaxed types of court. The Court of Appeal is not as relaxed as an employment tribunal, but nevertheless, even in the most minor tribunal, it is a formalised and a serious process, which for most people, and I'm not talking about people who have learning difficulties or people who have a poor education or perhaps can't read and write. I'm talking about for anybody, for any citizen who is not conversant with that. And so the corollary to that is nobody goes to law willingly, or very, very few people go to law willingly. And I just do not accept the Honourable Lady's premise that there are people thinking, oh, I might as well give it a punt because it's all on legal aid. I do accept the point that was made, that has been made, that sometimes being against a legal aided party may cause an imbalance for the party who is paying the costs themselves. That is a fact of life. It's one which we should pay attention to, but it's a different point. I simply do not accept, and I think it's one of the poor defences which the government has made to its bill. I've heard the phrase skin in the game used in this, which I find quite an insulting term, to the idea whether it is to make people more responsible, whether it is to make people think twice or three times, or simply not go ahead with litigation at all. I do not accept that the provision of legal aid, even where there is a nil contribution or a low contribution, acts as an inducement to people to take litigation unnecessarily. I'm not saying it never happens, but I do not think, which is the way that the government has tried to present it in the media elsewhere, it's a substantive part of litigation in this country. I would
Does he agree with me that I find, and I hope that he does, a smokescreen being put up that there's an alternative to legal aid, which is advice and mediation? Does he agree with me that that would be okay if at the same time that this bill is being pursued, the amount of money available for mediation and for advice through citizens' advice bureaus is going down? So what we'll have is a cruel irony of people thinking they can go somewhere else and finding out that those services don't exist.
Well, I will answer the point, but there's minutes want to come in before I answer.
I do thank the honourable gentleman for the intervention. And just to make quite clear that the government's proposals are to increase the amount of money going into mediation. We estimate by some £10 million, and that those who are eligible for legal aid will be eligible for mediation paid by legal aid.
Not to argue with at least both those points, because I hear what the Minister says. The Minister is right. Along with the £350 million at least, and the latest figures, cuts, there will be an increase. I think it's £10 million or 5%.
Not a capped amount.
It's not a capped amount, but nevertheless there is a notional figure that's put in there. And I'm just looking through my interesting bundle here for what mediators say about what the Minister says. But I don't think he can get away with that. Yes, we all agree. He will find there is consensus, as there would be in all good mediation, in relation to the role that mediation should play, that role should be increased, that if one can resolve matters through mediation, it may or may not be cheaper, that's the first point, because professionally trained mediators, of which there are not sufficient at the moment, somebody else probably hasn't thought of, that is not just on the cheap, but as certainly in terms of reaching an acceptable solution. Wait a minute. An acceptable solution, mediation is the proper way to go. But mediators themselves say it is not, neither is it the solution in every case, which is why they want to see the continued availability. This is the views of Resolution, which is one of the major mediation organisations in the country, and they of all people should speak up for mediators. They do, but they say 2 points. Firstly, that not all cases are suitable, and secondly, that having the ability to go to law if necessary is actually part of the process. But I will give way.
Well, I thank the Honourable Gentleman because I think I heard him say that there aren't enough trained mediators. I can tell him that as far as non-family mediation is concerned, there is no problem whatsoever. He may be referring to the expansion of family mediation as a result of our proposals, and I can tell him that the Family Mediation Council have advised that there are enough mediators to cover demand at the current time, and they see no problems looking into the future in the way that mediators are coming into the system.
Well, we have conflict. All I would concede to Minister is we have conflicting advice, because I've met Resolution, who I think he knows, and I think he regards as a reputable and respectable body, and they are seriously concerned, particularly in the family area, that they're not sufficient. Of course, they welcome the expansion of mediation. Of course, they welcome more trained mediators being available. But it is not the be all and end all. It is not the solution in that way. And I'm terribly sorry, but I think I forgot the previous point. But unless anyone's going to repeat it, I'm sure it will come up again. I have a feeling. You're going to remind what the previous point is.
No, I'm not going to. I'm grateful to my honourable friend for giving way. I'm not going to remind him what the previous point was. I'm going to refer back to the remarks which the honourable member for Broxtowe made, because surely her case that people go to law too quickly is an argument for example, changing the means test, changing the capital limits, changing the test across the board. What is so objectionable about what this government is doing is that whole areas are being taken out of scope, and those are particularly the areas which people on low incomes need.
No, I'm not going to that. I agree with that. I've now found my brief from Resolution, and they take exception not just with the fact that mediation is not suitable for all cases, but they also say when mediation fails, a parent will be expected to conduct their own application for contact with their child. This will include situations where a parent has no contact with their child, where their ex-partner refuses to attend mediation or cooperate in mediation, or where there are significant compliance and enforceability issues relating to a court order. Enforcement of contact orders creates very difficult issues for applicant parents and stark choices for courts, particularly around the committal of a parent with care of a child to prison, or the charge of or a change of whom the child will live with. And I'm not going to go on that sounds here. We'll come back to that again as well. But there are a number of detailed considerations which the mediation services have brought up because they do not believe that the catch-all, that mediation is going to provide the solution to all the problems which the government says it will do, and to all the cuts in scope which it says it will do. And I urge them to listen to the people who they're putting the onus and the responsibility on. So I come. Yes, that's right. I remember now. I was getting
Not at all. I'll thank the honourable gentleman for giving way. I wanted to go back to the point the honourable gentleman was making about people finding the court process troubling or unfamiliar to them, and that therefore is an experience that they find quite difficult. Therefore, does it not make common sense, along with their many other reasons, to look back at the principle of how we deal with conflict in society, and isn't the move towards mediation and other initial steps to stop people having to go through that traumatic process of going to court? Surely that must be welcome.
Well, I think I'm not going to disagree with the comment, because I think I've just said that mediation is only one alternative to litigation. You know, there's a long history of arbitration, of alternative dispute resolution, and of course negotiation and settlement of cases. So I don't think, all due respect to the Minister, I don't think he's come up with some brainwave here about how the justice system in the UK will change overnight. But well, the Minister's said position, he's not claiming to be a legal pioneer, but you wouldn't understand that from what the MOJ says through the media, which is effectively that they've got a new way of doing things. Well, I'll give my answer in a minute.
Yeah, well, on that point, I think, isn't that the root of this issue, that no one on this side of the chamber is suggesting for 1 second that mediation isn't a good thing. But we've heard from all the people who are involved in mediation to say it's not a suitable alternative to the access to legal aid. So if it was that before you can actually gain legal aid, you must go to mediation, that might be something that's worth pursuing. But it's not an alternative, it's not the same, and it needs to be part of a package.
Yes, but I will give again. I'll give the first point.
The shadow is giving us on this point, and let me just make clear. You know, we are saying that in many circumstances it can be a viable alternative. Not in all circumstances, but in many circumstances it should be an alternative that is used. And I say to the Honourable Member for Hammersmith that, you know, mediation is normally cheaper, faster, and can be much less stressful on those who use it. And that is why I've been promoting it. This is not some brainwave that I have come up with. This is looking at the established facts of a system which works.
All that is not only true, but laudable, except that the Minister says an alternative. But in many cases, it's not, there's not going to be an alternative. There's not going to be an alternative. That's what we object to. I go back, and I'm coming to the end of what I have to say on new Clause 1, so I'm going to go back. One of the few things I wrote down, so I remember it, and I'll go back and say it again. The two principles which we challenge here, firstly, are that I say that finance informs, not defines, legal advice and assistance available. And that's the point, the interesting debate I had with Honourable Gentleman for Ipswich earlier. And I think that's clear. It may be the single most important factor. And at the moment, I entirely accept that the government is making savings to the legal aid budget, and we would have been making savings to the legal aid budget, and they may well have been of the same order of their own. We would not have been doing it in this way, and we would have had regard to the fact that you have to end up with a coherent and an effective system for providing legal aid, and at the core of that, certainly as far as civil legal aid is concerned, is making sure that poor people and people of moderate means have access to the courts, and that there is an equality of arms, and that they are not disenfranchised by the fact simply of their lack of means, either because they have to contribute themselves, or because lawyers are either not available, don't exist, or are not commercially able to take cases on. And the second point is that litigation is a sometimes necessary step, and the availability of legal remedy is an important safeguard of decision-making, equity, rule of law, and free expression. And that really, the first point on finance is the usual arguments, I say, that we have. I just think it's been applied, it's being applied in a more than usually ham-fisted and oppressive way in this bill, even than it is in other bills that have gone through or are going through the House at the moment. The second point is what I'm particularly concerned with, and why I've spent some time looking at the way that legal aid has grown up in this country, the principles that had all-party support 17 years ago, and the change, notwithstanding the Honourable Beaconsfield's comments, that came about in 1999. I think, with all due respect to him, the Honourable Beaconsfield misunderstood what the intention of the, or at least in that debate, sure he doesn't misunderstand it now, of the Access Justice Act was. It was not to set some sort of political template for access to legal services. It was to begin to look at the relationship between society and legal services, which of course was already happening. It had happened through the Law Centre movement. It had happened through not-for-profit organisations. It happened, of course, through CAB, which has a history going right the way back, I think, to the Second World War itself. And the fact that there was a continuum and a variated response to people's levels of need for advice, representation, and so forth. And that when we should not, as lawyers, work in a vacuum, as may have been the case prior to that, that we should see ourselves, or legal preference should see themselves, as part of a process which was delivering justice. And that's why, whatever the changes in resources that came about, the principle of the Access to Justice Act was in its own way as important as the principle of the Legal Advice and Assistance Act in 1949. And that's where I think we were. And I think despite the expansion of legal aid, despite the previous government's attempts to control that, which were successful and which would have continued, that we are now in a different ball game. We're in a ball game where the government has not only decided that finance is not just the main or a main motivating factor, but is the be-all and end-all of deciding this, and that the downside of that, what we would see as the downside of that, which is my point too, is actually, and I say this with some regret, is actually something that the government is either indifferent to or positively welcomes. And I say that because a lot of the Minister's comments in public have been to the effect that depressing litigation is an end in itself. There is too much litigation, too many people go to the courts too readily. Now, as I said, I do not think that is the case. Even if that were the case, and this will be a recurrent theme as we look at the bill, parts 1 and 2 in particular, the remedy is a remedy too far. It is a remedy that kills the patient. What I believe will be the consequence, the cumulative consequences of part 1 and part 2 of this bill, is it will remove from the public realm much of the ability that individuals of all types of means, say the most wealthy, but particularly the poorest, to receive redress, to be able to get proper representation, and to be able to, where mistakes have been made, particularly by big corporations, whether they are government departments, businesses, or what you will, employers, in all the situations for which social welfare legal aid has grown up, that will no longer be a recourse. And that will be the case from CABs and law centres and private practice through to preparation for trial and indeed trial itself. And that is the significant change. And what we seek to do in new clause 1, and I don't imagine the Minister will be supporting it, but he may have had a change of heart, who knows. What we are trying to do is to put back those principles which have been tried and tested over that time. Sometimes I think the government talks as though these are luxuries, that the ability to go and get advice on debt or the ability to go and get advice on housing benefit arrears are. The government has several answers to that. It either says that's not a legal matter, or it says somebody else can help you with that, a volunteer could help you with that, a pro bono organisation. The very people who have committed the wrong or the tort in the first place can help you with that. The tribunal can help you with that. It's when you look at the government's alternatives to the current provision that you see how lame those reasons are. And what I take exception to is the idea that there is somehow out there in our constituencies that there is some Shangri-La of free advice, free representation, that you can walk off the street and you can immediately, at no cost or inconvenience to yourself, have all your problems sorted out. I don't believe that any one member here, however prosperous their constituency, because all constituencies have areas of need, actually believes that. And from our own individual experience, we know that people often are reluctant to seek advice, don't know how to seek advice, but when they do seek advice, that they are either already in extremis or certainly unable to deal with problems. And one of the things that we have tried to do over the last 10 years is to deal with that very problem by trying early intervention, by things like the Financial Inclusion Fund, by the expansion of law centres and citizens' advice and Advice UK networks across the country. And there are already concerns. There were concerns under the last government about advice deserts. the whole country will become an advice desert if these proposals go through. And that's why we say it is important at the beginning of this bill to set out and state those principles which have defined legal aid and which we have learnt the lessons of over a period of 70 years. And that's, again, why I say that the radical reform of this kind, which is not a constructive reform as the two previous acts were, but is a destructive reform, the government does at its peril, because the consequences will be, as the equality impact assessment registers, will be a lack of social cohesion, will be increased criminality, and will be huge distress for people. I mean, I don't know what other members do, but I spend my Sunday mornings going around knocking on doors, and particularly in areas of need, in areas where people will not necessarily access services. And I find things which shock me greatly in the 21st century in terms of conditions that people live under. I've found people who are pensioners who haven't received their pensions for 5 years. I found people who are living in uninhabitable conditions. And I think it still, even after 25 years of doing it, it still shocks me when I sometimes see the conditions people live in, and often, particularly in constituencies like mine, it will be cheek by jowl with people who live lives of comparative luxury. And it is those people for whom the services which have grown up around legal aid and advice over the last particularly 30 years, but even before that, benefit from, and it's those people who will lose those services as a consequence of the bill. So that is the means and purpose of new clause 1. If I turn now, and I can deal with the other clauses more speedily, because as the member for Ipswich so perspicaciously says, there is a degree of overlap. But that is to help the committee rather than to hinder it. So looking at the lead amendment, Amendment 60, what that says is the provision of legal aid must promote and ensure access to justice by providing legal services to those unable to afford it, ensuring equality of arms, and delivering services in the most effective and efficient manner. And I confess that I cribbed part of that myself, not from the Legal Services Act in New Zealand.
Which you take no regard.
Which is because there are some good things in New Zealand. not just Lord of the Rings and so forth. And that says, Section 3, purpose of Act. What a revolutionary proposal that is. I didn't the minister think of that, to put the purpose of the Act at the beginning. When he's setting out the Lord Chancellor's powers in Clause 1, why didn't he think to tell us what the purpose of the Act was? Perhaps he was embarrassed about it, for the reasons that I've just given. Perhaps that is the real reason. But I think, nevertheless, he should have bitten the bullet and done so. What the New Zealand Act says is the purpose of this Act is to promote access to justice by establishing a system that A, provides legal services to people of insufficient means, and B, delivers those services in the most effective and efficient manner. It's not quite the same, but I think it does the same job. And it's not as flowery or as elaborate or as relevant to, I think, our past history as New Clause 1 is. But I think it does the job in a succinct way by being clear about what the purpose of legal services is in a very short and clear way. And I promise you I hadn't seen this before we drafted the clause, but when I was looking through the Access to Justice Act second reading debate, I found, and if I can find it here, I will tell you what it says. I should just observe one other comment that was made during the course of the 1949 Act. The government have received the fullest support from both branches of the profession The Bar Council and the Law Society have worked on this matter with a degree of cooperation between each other which has hitherto been quite unequalled. Now, I don't think that's going to ever be said on other occasions, can it? That not that the government, the opposition, the Bar Council and the Law Society were all of one mind. There we are, and that will please the honourable gentleman for Ipswich to know that there were times when we could all get on terribly well together. The 1999 Act contained a similar provision. It was a provision that was in the government's, the then opposition's own amendment. And when I lay my hand on it, I will read it to you because it makes an interesting comparison. But this is a brief and short amendment, providing legal services to those unable to afford it, ensuring equality of arms, and delivering service in the most effective and efficient manner. If the honourable members opposite don't feel minded, for whatever concerns they may have voiced, or even perhaps if they haven't voiced them, if they don't feel minded to support the new Clause 1, I hope they will have no difficulty in supporting Amendment 60, because I think it just sets out very basically what the principles of legal aid should be, without any embellishment. I found the amendment I was looking for. This was the amendment put forward and passed in the House of Lords in consideration of the Access to Justice Bill, that persons have access to legal services and the machinery of justice which they would otherwise be unable to obtain on account of their means, that legal services and facilities of high quality be available such that disputes may be resolved and proceedings determined expeditiously, fairly, and with the parties placed on equal footings. Slightly more verbose, but I think it says the same thing. And that's a proposition which the Conservative Party was very keen to support in 1999. I don't see any reason why they shouldn't support a similar provision in this year. So I'm not going to say any more in relation to that list. I think there was a question on it, but I've forgotten what the question was. And if the person who's going to ask it has forgotten that as well, then I won't trouble them any more in relation to it. I'm not going to deal with at this stage at least, with the amendments standing in names of honourable friends. I will allow them, when I sit down, to put their own case in relation to that, and if I've got any further comments, I will add them later in this debate. But I would like to deal with Amendment 61, which is, I'm afraid, long amendment, not one I'm going to spend a long time on, but a long amendment that stands in my name. And the purpose of this amendment is really to look at, and it will partly be covered in the, I think, when my friend for Hull speaks on his amendment, the concerns that we have about the repeal of large parts of the Access to Justice Act and the requirements which that puts upon the Lord Chancellor, and which are now the Lord Chancellor has a much freer rein. There are dangers, and we will come on when we look at Clause 4. There are dangers in the abolition of the Legal Services Commission because it's not something which we oppose in principle, indeed it's something we propose, but we want to see proper safeguards in relation to that. We also want to see proper duties on the Lord Chancellor, which I've indicated, and proper scrutiny of the Lord Chancellor, because under this bill, and particularly with the repeals that it makes to the 1999 Act, the Lord Chancellor has far fewer responsibilities and far more leeway. And so, looking at Amendment 61, what that will say, that's a new amendment, little subclause 6. In carrying out the functions under this Act, the Lord Chancellor shall protect and promote the public interest, support the constitutional principles of law, ensure no denial to access to justice, ensure that access to legal, and I think I've dealt with those 3 points, ensure that access to legal aid complies with Article 6 of the Human Rights Act, taking into account any guidance provided by the European Court of Human Rights. Again, perhaps our members may say that it's OTOs to put that in, but I think it's right at the beginning of the Act to be clear what we're saying. Members are familiar, I'm sure, with Article 6. Everyone is entitled to a fair and public hearing within a reasonable time by an independent and impartial tribunal established by law. If a person has not sufficient means to pay for legal assistance, be given free when the interests of justice so require. Guarantees the right to a fair hearing in civil and criminal proceedings. Protects the right to take court proceedings to settle a dispute. The right to legal aid where the dispute is very complicated in order to advantage because you cannot afford a lawyer. Those are explanatory notes as well as the text of the article as well. And I think it's right for all the current air war there is over Article 8 and other matters relating to the Convention and to the Act. I think it's right that that article is very clearly in the mind of the Lord Chancellor when he makes provision for legal aid. It is fundamental not only in criminal but in civil legal aid. Little subclause 7 says the Lord Chancellor must each year lay a report before Parliament explaining his legal aid strategy. And it defines a legal aid strategy is a strategy under this section setting out the measures that the Lord Chancellor has taken in the past 12 months and the measures he proposes to take in the next 12 months for the purpose of complying with subsections 3 and 6 in accordance with the principles in clause 1(2). And little 9, the Lord Chancellor must each year lay before Parliament a further report describing in his opinion the extent to which any changes he has made to the amount of expenditure on civil legal aid has caused additional costs to other departments of state. And finally, for completeness, I read little 10. For submitting a report to Parliament under Section 1(9), the Lord Chancellor shall submit a report to the Controller and Auditor General for approval. Now, that makes all sound very bureaucratic and additional requirements. The reason why we think it is important, firstly, that there is a legal aid strategy, because under this Act, the Lord Chancellor, as I've said, has a great deal of leeway. He has a great deal of ability. He has the ability, under secondary legislation, to remove matters from scope, not to add matters from scope, but to remove matters from scope. We do not yet know, and the Minister may be enlightening us during the course of these proceedings, how much secondary legislation we're going to get, what form it's going to take, what areas it's going to cover, what it's going to cover. We do already know that there are significant areas that are not in the bill, and which we frankly expect to be in the bill, even if the Minister is going to say his advice is this is not the requirement of primary legislation. We would like to see, where substantive changes are being made to areas of law, that we are clear when we are debating them what those changes are in the round. And one example of that clearly is in Part 2, where we have the reservations and qualifications on CFAs, the no recovery of success fees, no ATE premium, recovery from claimants' damages, damage-based agreements, all there, but the mitigating factors not there. And the Minister may say, I suspect one of the reasons for that is that they're not ready. That the Minister has no more idea than I do how TWOCs are going to work, for example, and that is a work in progress. But I say it's simply not good enough. We should not be making major changes to civil litigation without knowing what the package is in the round and without considering it in the context of this bill. The Minister could equally well, and I'm glad he hasn't, have said that many of the scope changes would be outside the bill and would be dealt with by secondary legislation. That's effectively saying what he's saying may happen in the future by giving that power to the Lord Chancellor, and that's something which we are suspicious of, particularly as it's a one-way street to further reducing the scope of legal aid rather than the ability to reduce or increase it. But the fact, I suspect also that the reason that the Minister has put most of the scope changes into the bill is not so much to enlighten our debates as to fend off the possibility of judicial review, which will be easier if it's in primary rather than secondary legislation. But I simply say, I'm not going to use the dog's dinner phrase again, I will use a more precise phrase, which is this is a very partial bill. It deals with certain matters which the government wants to deal with. It promises it will deal with other matters, but it doesn't. And therefore, it is very important that going forward from here, that there is proper scrutiny. If the bill is enacted in anything like its current form, it leaves the Lord Chancellor in a very powerful position in terms of what type of civil legal system we will have in this country in the future. And if he decides in a year or two's time that the savings have not been made, for any of the reasons I've given earlier, including the fact that many of the cuts will actually cost the public purse more in the long run, and therefore decides to have further scope changes to restrict it, there will be very little way of keeping an eye on that, other than through SI committee.
He's speaking very eloquently, but he will appreciate that as the law stands at the moment, the Lord Chancellor could change the schedules and therefore what is within and out of scope by order.
Yes, I am aware of that, but we haven't had a government previously that had declared war on legal aid. We haven't had a government which has the intention of, the Minister's best argument would actually be, I've done all the dirty work now, there's not much left to cut in the future. But I suspect that they are still leaving the door open to that. Anyway, yes.
Isn't it better to do what we're proposing to do, which is to present what we want to have within the scope of legal aid to Parliament and to debate it in the form that we're debating it now, rather than the system that the last government bequeathed, which was only to do it by order?
Yes, it is. But as I've said before, I'm suspicious of the Minister's motives for doing so.
I think the minister's view would be okay if there was some detail about how the system's going to work. Isn't the practical problem that the Chancellor would have discretion to use? He will use that discretion. Nobody has any idea about the parameters where he will use that, and it could exclude or include people. Isn't it up to the front bench, I think, to set out some general principles that at least we can understand when we're dealing with this bill? Because it seems to me the reason it's being described as a dog's breakfast is as such an important detail that's not being included in the bill.
Well, I think, as I've said, I won't repeat it, I do know what the principle underlying this bill is. The principle underlying this bill is to eviscerate legal aid, and it's as simple as that. What I don't think we know is exactly how what is going to happen. I don't think we know, because I think the government knows, because this is such a radical reform, it has such a deleterious effect in relation to the advice and representation sector, that it is very likely, and I make this prediction, I hope I'm here to see whether it comes true or not, that what is set out in the bill will not be the limit of damage, because so much is taken out of scope, because of the cuts to remuneration from people who are already quite poorly paid. We will see not just the disappearance of firms, agencies, and the areas of scope which we know about, but we will see disappearance of whole areas of scope. So where the government has, and I know the Minister will at some point, probably when we're talking about Schedule 1, will say we have been careful to protect those areas of legal aid which go to life and limb, for want of a better phrase, where loss of a home, asylum, other cases, and that has somehow been some sort of filleting which has taken the necessary core out of the current provision of legal aid. I'm afraid I don't think it's that at all. I think that was that's a sort of PR effort. That's the things which to have got rid of them would have been wholly indefensible rather than just indefensible, and for that reason they had to be left in. And we saw one or two, but only one or two very minor amendments, the area of special educational needs, education, and a slight widening of the provision on domestic violence, but otherwise no real change at all. So whereas the Minister may say I'm presenting a different encapsulation of legal aid, I say, no, you're not. What you're doing is you are effectively ending provision, certainly of social welfare legal aid, and where you have left provision, in many cases, it will not be sustainable. It will not be sustainable because actually we get a very good deal at the moment out of the providers of legal aid in this country. And I'm not talking about top QCs. I'm not talking about very high cost cases in the criminal courts, which take a sizable chunk of money. I'm talking about legal aid solicitors and barristers. I'm talking about CABs with legal aid, with LSC franchises, law centres, and what you get with them. Because you don't, for your money, you don't just get them and people earning low sums of money. Well, I've found out what people managing CABs, who are managing lots of staff and volunteers, are earning, or what legal aid lawyers are earning. I've been on the management board of a law centre for over 25 years. You know, we are not talking about people who do it for the money. We're talking about people who do it, to use an old-fashioned phrase, as a vocation, and who are generally passionate about what they do, but who bring with them a whole panoply of other benefits. CABs run partly on volunteers, often in a ratio of 4 or 5, or sometimes even 10 to 1 compared with their ordinary staff. There's a very symbiotic relationship between the practitioners, legal aid practitioners, and the pro bono market. I mean, most obviously, where legal aid is available for preparation, but not for representation in tribunals, but you have somebody, which is very frequent, who even with the assistance in preparation cannot represent themselves, and then you go to FRU, or then you go to a city firm who is prepared to put somebody up to do that case, even if it's a 2 or 3 day case, for nothing. But that won't work either. If you get rid of what's the infrastructure which supports that, the legal aid lawyers, the legal aid solicitors, the law centres, then it is fanciful to say that the pro bono sector, the free sector alone, is going to deal with that. So that's why I say the consequences of this are far more than what we read in the bill as drafted. And that's also why I think it's very important that we have not just regular review, and I'm sure there will be scrutiny from the professions and others, and indeed from MPs as constituency MPs, but there is a formal process of reporting so that we are clear that whatever duties are set down for the Lord Chancellor, he has to make report to this House, to Parliament, in relation to those duties, and to do so once a year. I don't think that's an onerous duty. I think it's a requirement, and I hope that will get support. And the other document which is mentioned there is is looking at the amount of expenditure and whether there have been additional costs. And again, I'll be brief on this because we've dealt with this partly already. I mean, there are 2 possible ways in which there could be additional costs. One is if, as a consequence of not receiving early advice or even representation, somebody falls on the state. And the most obvious, most expensive example of that is homelessness. And I know the Minister will say that in cases where homelessness is an issue, that legal aid will be available. Well, again, I speak from experience. Often the problems that lead to homelessness are cumulative and complex. They come about through a variety of family circumstances, debt, failure to understand, and failure by typically a local authority not supplying housing benefit, or getting into debt and not prioritising debts. So by the time legal aid becomes available, it's too late. There isn't actually anything which the lawyer can do because the person is in debt, isn't paying their rent, and at that stage there's very little the court can do, particularly if there's statutory grounds for possession.
My friend agree with me that actually it's a waste of money just to focus on the homelessness issue and the problem of losing the home if the other debts are still mounting up and still remain because the underlying problem is still there and that person is likely to find themselves in that situation again.
Yes, I mean, I think we're all, certainly all over the local authority and housing association estates in my constituency, there are stentorian notices that say, pay your rent at all costs, and make it very clear that that is the priority. It doesn't matter, loan sharks, other debts, utilities bills and so forth. If you don't pay your rent, then you will not have a roof over your head at some point. And local authorities are much more assiduous these days, again because of financial pressures on them, in pursuing possession orders than they were previously. But living the life of somebody who has got themselves into debt and who does have perhaps a not very nice man knocking on the door every day or ringing them up 10 times a day and asking for what little money they have, means that doesn't always work. And so there may be nothing by the time a lawyer is engaged that a lawyer can do. But if, as is the case at the moment, you go into Mary Ward Legal Centre or you go into Hampton Fulham Law Centre and you say, I've got problems with housing benefit, well, that could be an issue. And this is where I think there is a general advice, a general assistance. But often, because you've actually tried that to reason with whatever authority it is at that point, often it isn't an issue where you need somebody who understands regulations, that understands what is going wrong, who can get their way through the bureaucracy, not just in a lay sense, but in a legal sense, to ensure that the authority deals with you properly, pays your housing benefit, ensures that your rent is not in arrears, or at least that your debts become manageable. And that means that you're not in that situation. It is fatuous to say that simply providing legal advice and assistance at the last moment is a way of ensuring that people don't become homeless, or people are able to live a family life as refugees and asylum seekers in the UK, or many other examples that no doubt we will go on to consider. And so, looking at that, not from a humanitarian point of view, but from a financial point of view, the cost of homelessness runs into tens of thousands of pounds in each case, because if it is a family for which there is who qualifies under the Housing Acts as being in need, and which the local authority has an obligation to, and so far, thus far, although nothing would surprise me, the government has not repealed that legislation. It has said that you can discharge obligations permanently into the private sector, but far from costing less, that often costs more. But the overall cost of homelessness, which could involve family breakup, could involve children going into care, could involve a loss of employment, and many other ways, not having a roof over your head, can clearly be something which is hugely damaging to any individual or any family. Will cost not a few £100, which the legal advice has been removed would have cost, but several tens of thousands of pounds. And that may be an extreme example, but you can go through, and I'm sure we will, every area of social welfare law and come to the same conclusion.
Honourable friend agree with me that the cost of early intervention, where all the debts are dealt with, at a cost of £200, because that is how much you are paid for a debt case under legal aid, is much cheaper than actually even going for the first possession proceeding, which is the first stage of losing a home.
Yes, I mean, you can go into any county court on possession day and you will see lists running down the walls of people whose homes are up for possession. And even that is still a relatively early stage. There will be, and I understand that the Minister has clarified that that service will be preserved, and I'm pleased that will be preserved because it's an essential service, because often people come, that is the first contact they get with any professional advice, and as a consequence of that advice, they may find that their case is adjourned, or that they are not going to lose their home, or even that they have a defence at that point, and a deal can be done at that point. That often is the case. But if that's not the case, but the possession order is not granted, or suspended possession order is granted at that point, then the opportunity to go away, you're now in touch, and you can now be put in touch with the infrastructure of advice that exists in your area, if it still exists. I will give that.
I'm very good. Wouldn't the government's position wouldn't the government be in a better position if, like we've heard today, that mediation is not limited if we had the same sort of criteria being applied to the Citizens Advice Bureau, for example, Debt Council and everyone else, so that they could maintain their budget. And it's simply not good enough for the government to say, well, we've put extra money into those services, when they removed massive amounts of money out of local government and other agencies, where they've now had to reduce or at least hold their budgets to the Citizens Advice. So they're not looking at a holistic way. What we know from our own experiences, that many of those organisations are struggling and that the government aren't finding resources for them.
Yeah, well, let's be fair, because that is the point we're dealing with in the little line here. So let's be even-handed about it. The government has done two things. One, it has extended the FIF for a year, Financial Inclusion Fund, and secondly, announced in a clause, in a sentence, in the Lord Chancellor announced £20 million that will go to CAB. Now, I don't know. What I don't know is what the details of that scheme will be. I understand it's for this financial year. I do not know how it is to be distributed or exactly to who or on to what basis. And importantly, if both those sums of money expire at the end of this financial year, what provision is there going to be for that type of advice service? So, as Honourable Mayfield eloquently said, that is probably the most cost effective. The catching things at the earliest stage and ensuring that further costs to the public purse, as well as social costs, do not build up after that. And that would be very helpful to know. It may not even be the Minister's department, and that may be one of the problems, because I'm afraid there's a lot of buck passing here. And when you hear that the Minister or the Lord Chancellor blaming local authorities for cuts that they've made to CABs or to law centres, is absolutely right. My law centre has lost 100% of its local authority funding. But that's as a consequence, at least in part, of the cuts in DCLG budgets or in BIS budgets. And of course, until the last bit of reprieve, the whole of the Financial Inclusion Fund was also going. Now, we understand, yes, there is that extra money in there. It does not even compensate for the cuts that there have been this year to those. It clearly is welcome. I'm glad that the government has done it in both cases, but it does not even compensate for the cuts this year. It bears no relation at all to the cuts we're talking about in relation to this bill, and we do not have a clear indication either how it's going to be administered and distributed, or, more importantly, what the future of additional provision. I know the game that the government is trying to play here. It goes along with their narrative about how advice is something that is a non-legal, that anybody can give advice. That you can go into a CAB. I think I was going to say something that was probably unflattering to CABs, which is that's what they were like 50 years ago. That you'd go in there to get to ask directions or to find out where your police station was or something of that kind. Actually, when I was reading the Ratcliffe report, they talk about CABs there, and even then, even back in the 40s, they were doing extremely valuable work and professional work. But certainly now, partly because of the LSC contract, partly because they are very sophisticated organisations now, they give a variety, they are able to assess and give advice at different levels, and some of it may be generalist advice, but much of it is legal or quasi-legal advice. Otherwise, of course, it wouldn't qualify for LSC funding. And so let's lay that myth, let's put that to bed. We are told that the Cabinet Office is looking in the round at provision of advice. That's a good thing, provided what we end up with is not a second-rate service which only caters for very, very basic levels of advice and assistance. We have to have, or rather my constituents, I should say, all our constituents, have to have the ability to retain what is there at the moment, which is a very high degree of professional advice. I'm patronised members, because I'm sure they have all visited their advice agencies where they have them very regularly. But I would advise going to somewhere like Mary Ward in London, which is in Holborn, is nearby, and seeing the service that is provided there. it was a revelation to me, and I thought I was pretty familiar with what was provided. And that's what I fear. What I fear is that, firstly, the consequences are going to be greater than the government either intends. I don't ascribe any adverse motives to it. I take the bill as it stands. I simply put the warning that there will be consequences, even if they're unintended consequences, in the collapse of the advice sector. The knock-on effect of that... Yes, I will give way.
I thank Tom Griffiths for giving way. Whilst I acknowledge that clearly local authorities are under financial pressures, does he recall that when, on the 14th of July, I asked Julie Bishop and Gillian Guy about the level of funding, whether there was any uniformity in terms of how CABs and law centres were being treated? In their responses, they said that there was, in fact, a wide range of responses from local authorities, where, for instance, one law centre got a 12% increase, whereas others, as his did, had a 100% cut. And again, with citizens' advice bureaus, there was no uniformity of response. So local authorities do have some leeway as to how they treat their advice centres.
They do, and I praise those authorities who have been able to protect. Some have, a very small minority, have prioritised to the extent that budgets have increased, even by a small amount. And I'm sure that that is in response to the much greater demand, let's not forget that other side of the equation, that there is as a consequence of people particularly being in economically poor circumstances. I will get in a second, economically poor circumstances. But, that is looking at things through very hazy vision, if I may say so. The overwhelming impact of cuts so far, and that is obviously before we get on to any of the things we're talking about in this bill, has been horrific. And I will use, I'm not going to, don't want to be overly parochial about this, but if you went back 2 years even, when there was a Labour government, certainly if you went back before that when there was a Labour local authority as well, in Hammersmith, we had 4 superb generalist advice services. We have an excellent CAB, which I'm pleased to say is still going, but is having to do 2 or 3 times the amount of work that it did before, and is being forced out of premises and not assisted at all with its move to new premises. We had a council-run, very well-established 30-year advice agency that was where I used to do my surgeries, and one day I turned up there and it had gone. The staff, the equipment, everything had gone. It had just been closed overnight. We had a specialist housing advice service called Threshold that operates in a number of London boroughs, which was forced to close because of the withdrawal of all its local authority funding after 30, began since 1978. And we had the Hammersmith Law Centre, which has lost all of it, 100% of the knowledge of its local authority funding, and is only surviving through its own extremely effective fundraising, including myself and Baroness Hale doing the sponsored walk on their behalf. And I'm delighted that the Justice Supreme Court is their president now, and that gives them additional profile, indeed Lord Bingham was beforehand, which shows the esteem in which the organisations are held by the senior ranks of the judiciary. But they are all under far more... I mean, I'm afraid I'm old enough to remember the last time this all happened, which was in the early 1980s, when again there was a studied campaign to remove funding from law centres and advice agencies, and many of those in London, I'm not sure the old gentleman's old enough, even though he is a Privy Councillor, and I do congratulate him on that, he's old enough to remember that, but basically they hung on for a couple of years till Ken Livingstone found the money to keep them going. This is not the first time we've been in crisis. It is the first time for 30 years.
Alan talks about the closure of law centres. I wonder whether he would join me in congratulating the South Swindon, the member for South Swindon, who's campaigning for his local centre. He was quoted in the Swindon Advertiser as saying, "My view is that these changes are to go through. There's a case for organisations like the Law Centre to get special funding in recognition of the fact it plays a very important role in looking after the vulnerable." Richard Hazel, the housing solicitor at the centre, says that if the bill goes ahead, it will effectively close them down. Can you explain to me how he can square, the honourable member can square his campaign alongside his support for this bill?
Members obviously don't think we're stalking them. All I would say about that is that whereas I always look for the bad quotes, as I did with the my honourable friend only looks for the good that honourable members opposite do, and so we will all join in supporting the honourable member for Swindon South in his laudable aim of saying...
Order. That concludes the committee's proceedings for this morning, and the committee will meet again this afternoon at 1:30. Order.